All rise. Hear ye, hear ye. Court of Appeals for the First District of Texas is now in session. So we're joined by state prosecution and its honorary judge.
Thank you. Please be seated. Welcome to the Texas First Court of Appeals. My name is Amparo Guerra, and I'm serving as panel chief today. And we also have Justice Jennifer Coy and Justice Clint Morgan on our panel. We have 3 cases on our docket this afternoon, but I understand they're all consolidated. We'll be doing one argument for all 3 cases, but to put on the record, they're case number 0123000193CV and 0123000194CV and 0123000195CV. And I will say generally Raymond James versus Stanton Welch et al. We all know which cases we're talking about. So starting with Appellant's Counsel, will you please make your announcements?
Yes, Connie Pfeiffer and Reagan Simpson for the appellants, and I'd like to reserve 3 minutes for rebuttal.
Thank you. 3 minutes.
Good afternoon, Your Honor. Russell Post, John Adcock, and Richard Midoff here for the appellees.
Thank you. Before we begin, housekeeping matters, not that either of you need these, but just as a reminder what our clock is for. Green means continue, yellow means you have 1 minute, red means stop. If you're in the middle of answering a question from the panel, feel free to completely answer your question even if the light is red. And again, we've read the briefs, which I have to say on both sides were excellent. But we don't need a recitation of the facts. If you want to just jump right into the legal issues, we very much appreciate it. So now we are ready to hear from counsel for the appellant.
May it please the court. Raymond James made the decision that it does not want business from risky activities like having its employees pilot planes, boats, and helicopters. Yet the plaintiff's theory is that a financial advisor could be within the course and scope of his employment while doing those activities as long as he is hoping that his passengers will become clients. That would be a dramatic expansion of Texas vicarious liability law for employers, and it departs from settled course and scope principles, which require 2 things. 1, that there be objective evidence that the employee is doing his job at the time of the accident. And 2nd, that the employer authorized either the general or the specific activity at issue. And that's where I'd like to start, because that prong of this test is frankly the trickier part of this. And I'd like to just set out this framework of how the general rule works and then how the exceptions work. So if we assume that Weiss was flying on April 22nd for business purposes, it is undisputed that doing so was violating express company policy. The general rule is that violating company policy is considered outside of your course and scope, and that an employee lacks authority to do that. That's what's set out in this court's Martinez versus Arafat case, where even though the employee was saying that he was doing so to hopefully develop business for the employer, this court held that doing the prohibited activity precluded any reasonable inference of course and scope. Now, there are 2 ways around that general rule. And the first is that the prohibited activity was likely to result from doing the job. That's the principle that's in the jury charge. And that's well developed in Texas law. There's lots of cases that explore this general proposition, that it's frankly in the section 230 of the Restatement of Agency, that a prohibition is just a factor to consider if the prohibited activity has a close connection to the authorized job duties. So I call these the escalation cases, and it's easiest, I think, to think about the nightclub bouncer who is prohibited from assaulting patrons, but part of being a nightclub bouncer means you might get more physical with the people in line. And so
Go
ahead.
So a few questions on this, and I don't want to take away from you, but okay, so first, the prohibition you have is clear in the travel and reimbursement expense policy. But then he was separately reimbursing flights on the personal business development policy. And my understanding is there is testimony from Charles Zimmerman, who was his supervisor, that this personal business development policy didn't include a similar prohibition. Is that correct? And assuming that's correct, how is that not some evidence that even though there is a prohibition in this in the official reimbursement context, maybe that it didn't apply, the jury could have reasonably inferred that it didn't apply in the personal business development reimbursement context?
So back up and separate the activity from the expense. The activity is what's prohibited generally in the company. You cannot fly planes for business purposes, even if it's entertaining clients. And so the activity is off limits, and expensing it is off limits. They're in separate places, but I think this is all undisputed, that this was not okay as a matter of express company policy. So then the question under this escalation test would be, well, is flying a plane something that is likely to happen just by doing your core job duties? Like the bouncer in the nightclub, it is likely that a bouncer might get too aggressive and slip into assaulting a patron just by doing their job. Or I like to also think of the speeding truck driver. A company might say you cannot speed while driving your truck, but it is likely to happen while on the road, and so it doesn't take the employee outside of course and scope just by escalating the activity. The second way to get around the prohibition is what's fully explored in the Texas Supreme Court's case that we've cited called Kennedy. And it's a little bit archaic. It's a 1937 case. It's not the easiest case to read, but it is right on point. And it is talking about where an implied authorization to use a personal vehicle for business, to do that, it requires the employer's knowledge and assent. The question in Kennedy was there express or implied authority from the employer for the use of the instrumentality with which the tortious act was committed? That is what I think the plaintiffs are really trying to get at with this case, is they're suggesting that with these expense reimbursements that there was some kind of implied authorization. They did not submit that. They did not plead that. They did not prove that. And
Well,
they did not submit
let me
that.
pause there. But they did. If you're looking at, there's the policy, but then there's the company practice. Didn't Mr. Strange testify that he didn't make any inquiry as to whether practice was different from policy, and there is this set of evidence in the record of reimbursements for flight miles?
So Strange testified that he was not aware of anyone who knew that Weiss was submitting these flight miles as automobile miles.
Correct, and that it was a misrepresentation, but didn't he also say that he didn't make any internal inquiry as to whether the practice differed from the policy, and maybe there's some evidence that in fact it did?
You mean generally or with respect to Weiss?
I guess either, but
yeah, I'm not sure.
Okay.
I think that when Weiss first came to his, like it was a complex manager over the Houston branches and said, can I expense these flight miles? He didn't know Strange
Right.
did not know the policy, so he had to go check. This
Right.
is PX 49.
right.
He found out you cannot, and not only did he forward him the policy, which was prohibiting the activity, not just the expense, he followed up with a conversation. And that's what we've cited in the bench exhibits.
Right.
To show,
Right.
to
Absolutely.
clarify.
Absolutely. I'll take you to a slightly different question on this, and it's the test and the charge is the conduct authorized by them. The action is of the same general nature as the conduct authorized by the employer. To what level of generality do we look at that? Meaning, is the fact that automobile miles are reimbursed, does that qualify, or
Yeah, it's an interesting framing question of how specifically or generally do you frame the authorized activity. So a financial advisor obviously doesn't have to fly planes. Now
Right.
they're going to say, well, this isn't about flying planes, this is about business development. And I will concede all day long, one of his core job duties was to develop business. So then the question is, well, do you have to fly planes to develop business?
Why is that the question, instead of could the jury reasonably thought he did fly planes to develop business?
Well, because it's prohibited. So this is the effect of the prohibition, is it takes the prohibited activity outside of course and scope, unless they can show that it's an escalation, which is the Section 230 principle and the bouncer cases and all of that. Both parties cite a lot of cases that fit into that category.
Right.
The other category is not real well developed in Texas law, and it's harder to find good analogs and examples. The Kennedy case is right on point. And it's talking about express or implied authorization to use a personal vehicle for business purposes. And the court goes through exactly what that would look like. That's the theory that never got submitted. And look, I'm not faulting my adversary for anything failing to submit something in the charge. They don't have the evidence to submit that. They didn't develop any evidence that anybody knew besides Weiss's assistants, who were beneath him in the seniority. They were the only people that knew that he was actually flying clients or prospects and submitting these expenses.
So isn't the issue that you spoke of and them not having that submission of sort of overriding a prohibition, not being submitted, is that not subsumed in question 2? Insofar as we were just talking about it's of the same general nature, and I don't find the escalation cases very analogous to this situation. So getting away from that and going back to general nature, I don't see how that's not subsumed within. If you want, and obviously you disagree, so you can explain.
Sure. So there's two very, very distinct ways of getting around the prohibition. They did submit the escalation way. That's the factor test. It's a factor. And so I agree with you. It's not really a factor case where you could say this is just an escalation and you're still closely aligned with court job duties. This would be a case where they need to submit a question on ratification or waiver or knowledge in the sense, something that captures the idea that the employer knowingly authorized an exception to company policy.
Wait, hold on, but you would agree that under this jury charge, the jury was told that the prohibition was a factor but not dispositive,
Correct.
right?
Yes.
So couldn't the jury have decided, well, it's a factor but not dispositive? And
Well, yes. Okay, that's right, and I think that's what they did decide here. And then the court needs to look at that from a legal sufficiency standpoint and say, as a matter of law, flying planes is not an escalation of developing business. He could have done all sorts of things that are consistent with company policy to develop business. He didn't have to fly a private plane. And that's just categorically, as a matter of law, not an escalation or likely to be done during core job duties. So that's the legal principle.
So, but I don't know if I see the question as did he have to fly planes as much as did he? And I think we kind of touched on that earlier. Not only did he, but had done so in the past.
I think that gets to the second prong of the test. Is the flight in furtherance of the business of Raymond James, which is a completely independent prong. Plaintiffs have to win both. And on that one, I think the law is quite clear and far easier to apply. There's several recent Supreme Court cases with Cameron, Painter, Lavery, that all talk about needing objective evidence that the employee was doing his job. So maybe he was mentally thinking this will lead to business, and there's no way to dispute that, right? Like, nobody knows what he was thinking, which is the point of the test, is that you need something objective that can be proven to show this was actually a business development activity or a core job duty, that we can know that it doesn't have to be direct evidence, it could be circumstantial, but they have to show he's doing the job at the time of the accident.
okay. I'll wait for everybody to ask that question. But can you just very quickly touch on the Martinez line of cases argument that you made about travel expenses and creating a fact issue on scope of employment?
Yes. So this is just a general proposition that can be found in course and scope cases that says that the mere fact of reimbursing personal travel, or not personal travel, but any travel expense, assuming travel is not your job, right? Like, this is not a truck driver. the mere fact of reimbursing the expense is not evidence that creates a fact issue about whether the employee was in the course and scope at the time of the accident.
So is your position that we can't consider the reimbursements?
Not to create a fact issue about course and scope. So if
But-
I think they're going to pivot now and they're going to lean on it as proof of authorization. So they're going to use it for the second prong. I don't know that there's any case that has said that that could be evidence of the authorized prong. It certainly can't prove furtherance of the business. And the proposition that gets repeated over and over as recently as the Supreme Court's Martinez case in 2022 is that it is no evidence to create a fact issue of course and scope generally.
But those are coming and going cases, so they're pretty different, right?
Not really. I mean, it's any case where the travel is not part of the core job duties. You're commuting. You're doing some kind of travel where the employee may or may not be in course and scope, depending on the facts.
But isn't this very different because the course and scope, and I'm keeping a timer to
Okay.
make sure we give, that's what I'm using my phone for, just, just so you know. I think in my view, it's the coming and going cases. In those cases, the difference is everybody comes and goes from work, and it's not that you're doing your job while you're coming and going from work in a car or motorcycle or whatever means that you're using. It's that here, there was business development happening in flight in the sense of, and I think there's evidence in this record, right, that you have to kind of court the prospective clients, and so in doing so, you're speaking to them in flight, and so there is presumably, if this is business development, that business development is happening while the flight is taking place.
Well, that's kind of the point, is that there's actually no evidence of that. Like that's the plaintiff's...
I'm saying there was the evidence of there being that here, the pilot of this plane, was in the business of courting clients, and to do so, you build those relationships through your personal interactions, and so this would be part of the personal interactions, not just the means by which you get to and from work.
Right. Well, let me leave you with this. That proposition, what you're explaining, that is the plaintiff's theory, and if that were basis to hold an employer vicariously liable, then everything a financial advisor or real estate agent or insurance broker or anybody in the business of getting business does could arguably be in course and scope. So the question to ask my friend on the other side is, what is your limiting principle? When are you ever not in course and scope if developing relationships is enough to bring you within your job duties?
Right, and how you answer the case law that says being on 24/7 doesn't mean you're in the scope of employment 24/7.
Right.
All right, I have basically 4 extra minutes there, so we can give you 4 extra minutes.
Thank you, Your Honor.
To make it fair.
May it please the court. If the court decides the case that is actually before it today, in light of the standard of review and in accordance with this unobjected to jury instruction, this is an easy case. It only becomes a difficult case if you indulge Raymond James's desire to ignore the standard of review and ignore that jury instruction. And I want to begin with the final point that was just made about a limiting principle. Because to affirm this judgment, it is only necessary to give effect to this jury charge that was stipulated and the objective evidence that Jeffrey Weiss classified the Kensingers as prospects at the time of this accident, and that Raymond James approved trips with them as business-related activities. Those objective facts establish a limiting principle that gives you a narrow basis for decision. If an employee and an employer classify conduct as business-related activity, the jury can do the same. And I want to begin in substance with the most important objective fact in this record, which you did not hear about in the opening argument and you did not hear about in the Raymond James briefs. And it is the PBDA policy. And I provided it for the court in tab 4 of my bench exhibits. Because it provides, and I call your attention to paragraph 6, Romanet 1. I've highlighted it there at tab 4. That business expenses that may be eligible for reimbursement under that plan shall be, and I quote, directly and primarily related to the business of the company and or the services provided by an eligible advisor for the benefit of the company. And if you look further in paragraph 6, it makes clear that the administrator has the discretion to determine whether expenses are eligible, and that decision is, quote, final and binding. All of the trips in which the Kensingers were treated as prospects were approved by the Raymond James administrator.
But they were labeled as automobile miles, correct?
They were labeled as automobile miles, but it was obvious to everyone that they were airplane miles. Not only was it evident to everyone in the Raymond James office that Mr. Weiss was flying clients and prospects, the testimony was he was not trying to conceal that. It was widely known.
But I thought the testimony from Mr. Strange was that nobody in management knew.
Well, of course, the managers denied it, and you would expect that the managers would deny it, and the jury doesn't have to accept their self-interested testimony. The jury could infer that the testimony of the staff members who said he wasn't trying to hide it signaled knowledge throughout the company. And I would make this point. I want to call your attention to a passage of the record that's not cited in the briefs. Look at volume 9 of the reporter's record at page 72 to 75. Don't take my word for it. In closing argument, the lawyer for the executor of Mr. Weiss's estate, who had no skin in this game, said he was so offended by the fact that Raymond James had suggested that Mr. Weiss had defrauded Raymond James that he took the occasion to say there is no support for that suggestion that Mr. Weiss was defrauding Raymond James. They knew it, and they had to know it. Look at what these reports indicated. They showed hundreds or thousands of miles on individual days of travel, not just with the Kensingers, with all the clients and prospects. I want to call your attention in particular to Defense Exhibit 84. That is a trip that Mr. Weiss made with prospects to the Masters Golf Tournament in Augusta, Georgia in April 2018, at exactly the same time as this pattern of activity. He called that a prospecting trip. Raymond James approved it. No one could plausibly have believed that he drove 1,887 miles in one day to the Masters Tournament. That's not the way people go to the Masters.
Can I ask you a question on this scintilla standard? I know there was
Yes,
a lot of discussion in
of
the briefs
course.
about statistics, and I'd like to understand your position. Is your position that if on one occasion, just once, Mr. Weiss had labeled the individuals on an individual on this plane as a prospect, that would be enough?
Your Honor, I think that it would not be enough if there was only one occasion
Why?
without any other contextual evidence to allow the jury to draw a reasonable inference that this trip was in fact business related. And so what I think is important here, this is what Raymond James wants to do. They want to indulge hypotheticals rather than deal with the record here. What you have is that in January of 2018, there is a trip in which there is an identified business related purpose, that is an estate planning discussion. And from that point forward, Mr. Weiss consistently reports the Kensingers as prospects. In nearly 80% of the flights from that event forward, he identifies the Kensingers as prospects. In one of those flights, he identified Reagan Miller as a prospect. 1 month before this accident, he identified a flight with the Kensingers as a prospecting flight. Raymond James approved all of them, which means under its policy, it has determined that they are directly and primarily related to the business of the company. They have never addressed this. When you ask counsel on rebuttal to explain how there's a lack of objective evidence, invite them to address this policy. It's cited one time in their opening brief with a CF citation without any discussion of the text. But when we called attention to the text in our brief, what did they say about the reply brief? Not a word. That's your objective evidence.
Is your
So-
position, go ahead.
Thanks. So going back to the evidence and sort of similar to if you only had one entry where these particular individuals, were labeled as prospects or prospective clients. Here, we don't have any evidence, and my heart goes out to all of the family and loved ones, that we don't have evidence from these individuals about whether or not this was actually a business development trip. So how do you deal with that? We do, and I know that in the appellant's brief they talk a lot about probabilities and And I understand that argument, but at the end of the day, we have no evidence for this flight.
You have no direct evidence for this flight, but what you have is circumstantial evidence. You have the same case that you have in any case, civil or criminal, where everyone who participated in the event was killed. You'll never have direct evidence of the purpose of an event where everyone died. We can't ask Mr. Weiss, we can't ask the Kensingers, we cannot ask the decedents of my clients. So you look for circumstantial evidence. The jury was instructed that it could draw reasonable inferences from the circumstantial evidence. You look at the pattern of activity culminating in that trip just 1 month before this trip, in which Weiss consistently treated the Kensingers as prospects. You look at the fact that Raymond James approved that as a business-related activity. The jury can draw a reasonable inference that it was in fact a prospecting trip. Now, they didn't have to draw that inference. This case was tried by excellent lawyers on both sides, and the jury could have said no to question 2. But they said yes, and we're entitled to all the inferences that support that verdict. Now, I want to turn...
Sorry, can we go back to the Defense Exhibit 5 with the this policy
Yes.
that you were talking about? And so what's your response to the argument, and you might have kind of addressed this already, that there were no sort of principals or vice principals of Raymond James who essentially approved of these reimbursements when they were disguised as automobile miles?
It is both legally and factually unfounded. Legally, it's unfounded because if you're going to make an argument that there has to be a finding about vice principal status, you have to request a vice principal instruction in the jury charge. That didn't happen. But put that aside, because there's an answer in the language of the plan itself. In tab 4, turn to page 3. In paragraph 10, the paragraph that's titled Administration, you'll see that in Romanet 10.8, the policy is administered by the administrator, and the administrator may delegate to one or more branch managers or similarly situated officers or employees of the company the authority to approve the reimbursement. And so the vice principal, the officer here designated to approve eligibility, has the power to delegate. That power was exercised. In every one of these expense reports that I've attached, the last entry you will see is an approval from the delegate of the administrator acting in accordance with the plan. And notice that not only does it allow delegation, but it makes clear in paragraph 10, Romanet 1, that they can determine eligible expenses hereunder and approve reimbursement of such expenses, notwithstanding any provision of this policy to the contrary. In paragraph 11, there's reference made to the corporate travel policy, the very policy that they rely on. But paragraph 10 says the administrator and her delegates can determine expenses to be eligible, notwithstanding that policy. And that's what they did, and that has legal consequences.
So is your position that essentially the company's practice didn't match the policy because of this?
It is absolutely our position, and you're exactly right that there was a concession in the testimony from Mr. Strange that he had made no effort to determine whether the actual practice matches the formal policy. And so let me turn to that line of argument, because this formal policy was not enforced in practice. And that issue was submitted in question 2. That was part and parcel of what was being debated in question 2, with an instruction about the effect of violating an employer's express orders. We were arguing that in fact there was no violation. And that's the narrow way to deal with this part of the argument. Because if you recognize that the jury had a sufficient basis to conclude the practice was not to prohibit Mr. Weiss from flying prospects at clients, then you don't have to deal with the legal question about the significance of violating an express order, because there was no express order that was being enforced. The jury had an ample basis to reach that finding. As I've already indicated, everyone in the office knew that Mr. Weiss was flying clients and prospects. He was reporting these obvious flight miles to airports for thousands of miles. They were being approved. That has legal consequences. And therefore, the jury was entitled to conclude there was no policy that was being violated. If you affirm on that basis, you need not even ask the question, what's the legal significance of a violation? But let me now then address that piece of the argument to bring it full circle. Again, remember what I said at the outset. Raymond James stipulated to this jury instruction. Counsel has made a very eloquent parsing of that instruction in an effort to get outside of its consequences. But the Texas Supreme Court consistently says, when there's not an objection to the jury instruction, you evaluate the sufficiency of the evidence in light of that instruction. And the instruction said specifically that conduct can be in the course and scope of employment, even if it's contrary to express orders, and said, and I quote, whether the employee is acting contrary to express orders is one factor
So
that
help
you may
me
consider.
understand this then, because you have this, let me state it correctly. Action is of the same general nature as the conduct authorized, and then you have this one factor language. I'll ask you the same question that I asked your opposing counsel. What level of generality does the fact that if you take out flight, does the fact that driving miles, is that the same general nature, or what is the same general nature?
I think that the answer to that question is provided by this court's decision in the Fink case, which we cited in our brief. It's an opinion by Justice Harvey Brown, and by the particular job description of this job. Because Justice Brown said, and I'm quoting, the pertinent question is not what motivated the employee. The pertinent question, he said, is whether the general conduct, not the particularly alleged misconduct, but the general conduct was conduct that served any purpose of the employer. This is part of the dual purpose line of authority for common law vicarious liability. If it serves any purpose of the employer, it matters not that it may also serve a purpose of the employee. That's a well-grounded rule. It is actually what the Supreme Court's decision in Lavery versus Weatherby stands for. It's what Justice Brown decided in the Fink case. That's the controlling rule. And so it says the level of generality is you look at the general conduct, not the specific allegation of wrongdoing. And the second piece of that, Your Honor, is to look at the job description here, because the general authority is going to vary with the particular job. And as you can see at tab 2, the actual job description for Mr. Weiss said that prospecting for clients was central to his job summary, and it was one of the essential duties of the job. We're not dealing with, as the case that counsel alluded to, the Martinez case, where a general laborer who had no authority to deal with cars was driving a car. We're dealing with a job description that called out business development and prospecting for clients as the essential duty of the job.
So how do you square that with the line of cases like Martin versus Village of Surfside Beach from our court in 2023 that says the fact that you're on 24/7 doesn't mean you're always in the course of employment. There are lots of fields like being a private practice lawyer where you're potentially, as a core part of your job, always prospecting for clients.
And we had this very conversation a couple of days ago. If I take clients to the Astros game and I expense it to Beck Redden and Beck Redden pays for it at business expense, it's in the course and scope of employment. And if I injure my clients on that trip, Beck Redden is responsible. The limiting principle is the fact that this is part of the job description, and Raymond James approved it as directly related to the business of the company. So you don't have to worry about it 24/7.
What? What is it? What did Raymond James approve? You said Raymond James approved it.
They approved these trips. They approved trips identifying the Kensingers as prospects as being directly and primarily related to the business of the company. That is in the policy. That is objective evidence. That has legal consequences.
And you're saying the Martinez line of cases that says travel expenses don't could affect
Completely
don't
immaterial.
apply.
Right. The Martinez line of cases, that's the coming and going rule. That deals with the rule that ordinarily travel to and from work is not in the course and scope of employment. And there's a special mission exception that deals with when there can be travel to and from work. And the court has said just because you get a travel allowance doesn't count. That's not what we have here. And I want to make this explicit, and then I'll yield the podium. We're not dealing with evidence based on the significance of travel reimbursement. We're dealing with reports that identified the Kensingers as prospects that were approved by Raymond James as being directly related to the business of the company. Those reports could have arisen in a variety of contexts. They could have been time records. They could have been client development reports. The fact that they arose in the context of travel reimbursement makes no difference. And on this point, I'll bring you back to your Fink decision. At page 471 of Fink, you will see that Justice Brown cited reimbursement of expenses as a portion of the evidence that supported the finding of course and scope. Because it's not just travel reimbursement, it's proving it was a business-related activity.
And evidence of authorization is, do you have any evidence of authorization from the company other than these expense reports?
Your Honor, the plan itself says authorization by the company, by the delegates is, quote, final and binding. I don't need any other evidence. I have evidence that the company itself says is final and binding. At the very least, the jury is entitled to credit that evidence, and its verdict should be respected. Thank you.
Thank you. And we'll give 2 more minutes. I think we went over 2 minutes there.
Thank you, Your Honor. I have about 4 points to make on rebuttal. First, let me start where we just ended. All the reimbursement shows is that a reviewing clerk in St. Petersburg, Florida, looked at these automobile mile requests for reimbursement and decided that it was met with approval with the PDBA plan and used Weiss's own money to reimburse it. That's all that shows. We don't know who these reviewers were,
Let me
and we
pause
don't know
you.
anything about what they actually determined.
You say they were automobile, let me put it to the right page here, but wasn't it clear? I mean, there were many, well over 1,000 miles in a day.
In some instances, yes. And so if somebody had actually sat there and thought about it and done the calculations or really processed this, they might have spotted it.
But they were approved.
Correct. But it's a huge extrapolation and speculation to say somebody actually noticed and then approved a financial advisor in Houston to fly his plane for business. The courts, Texas Supreme Court in Hancock versus Varium says you cannot speculate about who may have received information within a company. And they want to say, well, the jury didn't have to believe self-interested witnesses, which is true. But let me highlight a very important distinction between civil and criminal standard of review. In a criminal case, if the defendant takes the stand, a jury can believe that they're perjuring themselves and infer the opposite. In a civil case, plaintiffs always bear the burden of proof. So a jury doesn't have to believe the witness, but they don't get to believe the opposite. Plaintiffs still have to come forward with evidence. That's what they don't have. And they're pointing to a policy saying that the policy shows an activity on a particular day which is completely incoherent. You can't point to a corporate policy and say that shows what somebody is doing on the date of an accident. So
I think they're pointing the policy to say that these authorizations count as evidence that the company approved business development in this way.
They may be saying that some reviewer concluded that this meets with the policy parameters and rules. That's not saying that somebody has then decided that this is meeting Texas course and scope law. That's what's for the court, is does this evidence fit vicarious liability for Texas course and scope, not did somebody comply with the plan. Now, I do want to point out, when Zimmerman, the supervisor for Weiss, testified about he had flown with Weiss before, Weiss charged him for the fuel. It was not the case that anybody within the company understood that Weiss was putting expenses through the company. Anybody above Weiss was putting expenses through the company and calling his flights for business purposes. I'd like to address just real briefly Kennedy, because there is no way to read this jury charge and conclude that it is capturing the principle that the Texas Supreme Court is articulating in Kennedy, which is a categorically different way of showing authorization than the escalation line of cases. So if you can just keep the general authority with escalation line of cases in one bucket, and in a different bucket there is the authority that an employer could specifically, expressly, or impliedly authorize an activity, but they have to knowingly assent to it. It has to be something that they've repeatedly known about or seen repeatedly and authorized it. Finally, I'd like to end with the Martinez case and the travel reimbursement line of authority. What these cases are capturing is the fact that who reimburses an activity is logically unconnected to whether that activity is within course and scope. A person developing business could go out and entertain clients and not run the expense through, and that doesn't take it outside of course and scope. Or they could go just take friends to dinner and run it through the company. That doesn't necessarily make it business development. And so whether it gets reimbursed or not is, frankly, it's irrelevant. In this case, whether these people were called prospect on one day and not another is a red herring. Just assume that he always wanted to develop business. Assume that's his job. He builds relationships, He wants friends to become clients. We're not disputing that. But at some point, you have to have objective evidence about the activity that he's doing with them so that we aren't just speculating about what's in his head. The Lavery case says your intent is not.
Let me ask you, if we were to conclude that there's evidence in the record in which the jury could have determined that the company didn't enforce its policy, what would you do with that?
Well, at that point, that's an issue for, there is no theory in this case directly against Raymond James for failing to do something about enforcing a policy.
But why couldn't the jury have then said, well, this was just not dispositive then? The policy was not dispositive.
Well, I think they did say, they found that it's not dispositive insofar as that it was a factor, but that only fits with the escalation line of cases. There is no finding of knowledge and assent, any kind of ratification or waiver, however they wanted to capture that.
So you're saying that that idea was waived because they didn't submit a jury question on knowledge or assent?
There's three problems. No, it's not pleaded, it's not proven, and it's not submitted for a fact finding. And under the United Scaffolding versus Levine case, you don't have to object to a charge if a theory isn't pleaded, proved, or submitted, right? We don't have to object to the admission because they haven't done anything to capture this theory. Thank you.
Thank you.
Thank you both sides for your arguments today and your briefing, and thank you for the hard copies of your oral argument exhibits. This case is now submitted and this court is adjourned. Thank you.
All rise.